Okay, we're on the record in the matter of the people of the state of Michigan versus Christopher Michael Kelly, the file number 22-02157, council appearance.
Chris Martin for the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Christopher Kelly, who is present and standing to my right.
Mr. Kelly,
Good morning, Your Honor.
today is the date that was set for a preliminary examination. My understanding is that there is an unconditional waiver to the circuit court. That's correct.
That's correct, Your Honor.
Is there an offer on this at all?
Your Honor, the offer at this point is to plead guilty as charged, and we anticipate that he'll be able, and a Kilbrew agreement to no upfront jail time.
Mr. Kelly, do you understand that you have the right to have a preliminary examination here in the district court?
Yes, I do.
You understand that at the time of the preliminary examination, you have the right to have the prosecution bring sufficient evidence to establish probable cause. So they have to establish that there is enough probable cause that a crime was committed and enough probable cause to charge you as the person who committed the crime. Do you understand that?
Yes, Your Honor.
Do you wish to unconditionally waive your right to that exam today?
Yes.
Okay, you understand that that means once it's waived, you can't come back later and say you want to have your exam. This matter will be bound over to the circuit court without any hearing held here at the district court level to determine
Yes.
sufficient probable cause. You understand that?
Yes.
Is anybody threatening you to get you to waive your examination today?
No, ma'am.
Were there any promises being made to you to get you to waive your exam? And you're waiving your exam freely and voluntarily?
Yes.
Okay, and that's your signature here, sir?
Yes, it is, ma'am.
Okay, I'll bind the matter over to the circuit court for the bind over date of September 14th, 2022. You do not need to appear in court on that date. That's just the date they get the file from this court, okay, sir? Your next court date will be in circuit court, but it'll be a pre-trial. And Ms. Donnelly will be made aware of that date. She'll be in contact with you, okay?
Yes, Your Honor.
Do you have any questions today?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
None for defense, thank you.
Thank you. You're all set, sir.
Thank you, Your Honor. Have a great day.
Same to you.
Sarah, go.
This is just from me.
That's a different file.
You're all set, sir.
Yeah, I'll be right on.
If I may go excuse the officers who are here on Kelly.
Sounds good. I saw the,
Can you see again? This is for Holmes and Jones.
yeah, they're here
Silverthorne's
now.
here, but he's doing a waiver next door.
They're,
You know what's-
let me guess.
Guarantee you don't say.
So what?
Guarantee you don't get it on the first one. If you do,
Yeah,
I'll be shocked.
I'm not gonna. It's Thursday. It's payday.
Okay.
What? What is it?
My wife's 39 weeks.
There you go. That's a feel good Thursday for you.
She has her appointment today at 4:15, so
Anthony Jones and
Holmes Haywood.
Holmes Haywood, yes. Someone's in my way. Good morning. Good morning, can you hear me?
Yes, ma'am.
What is your name?
Trent Wallace.
Can you say that again?
Trenton Wallace.
Are we not having, she says a PCC?
Well, because they had just retained an attorney.
Oh, okay.
Yeah, this is PCC.
Okay, Mr. Wallace, I'm gonna put you on mute until your attorney logs in, okay?
Yes, ma'am.
Okay, let's see. Did you find out about your witnesses?
No one's here on Jones or on Holmes Haywood.
Okay. And Mr. Silverthorne is still on the record over there?
I can go check. You're still for?
Yes. Hi, good morning, Mr. Silverthorne.
Good morning, Your Honor.
Your understanding is that there are no witnesses on either of your matters. Do you want to bring your clients up?
No, Your Honor. What I typically would do is I'll go tell them afterwards. I surprisingly never had an objection to them not appearing for this.
I mean, I don't know, maybe they want to come up and say, you know, we don't want it dismissed. We want to hang in
I'm
there.
waiting for that to happen.
It could, you never know. I don't think today's that day though.
Just the experience of being in the courtroom with all these esteemed
They came
attorneys.
all the way this far, they came this far.
Don't give them the full experience.
Yeah.
If you want to go down there, that's no problem with me.
I've got a pending matter with Judge Flores, so. in the
Sounds
interest
good.
of
We'll prepare
judicial
the
economy,
nominee.
and I know you have a lot of PEs today, so.
Actually, it's clearing out pretty quickly.
It's amazing how that happens.
I know.
Yeah.
Holiday weekend.
Oh, it is, isn't it? I'm on call, so.
Oh, really?
For me.
I thought that the Thursday prelim docket was to facilitate, you know, an easier Friday for everybody, but it's apparently not.
Not for me.
It works out for us.
Yeah.
Really, post-COVID, there are no downtimes. There are little brief moments like this, but they're the exception.
Yeah.
It's true.
Okay, well, this will. Spread out on those two. What's going on with Harvey Edwards?
Do I need?
I think I'll sign it now. I
He's
think.
waiting
Okay.
for his turn.
I'm sorry?
Are you?
He's waiting for his attorney?
His
Oh,
attorney's
no, tell me
here.
what, is representing today?
Yeah.
He's here.
Can I ask
Toby
you-
White's doing it, but he's doing a waiver.
Oh, okay, that's who, James is from his office. Okay.
He said they're just waiting to see if witnesses here.
We're running that.
Said they were waiting for witnesses.
Their
Yeah.
witnesses?
Well, he said it will be a waiver, but they're waiting. He was,
Are your witnesses here?
What's this?
Are your witnesses here for Harvey Edwards?
Well, I'd like to ask a hypothetical question, not in regard to any particular case,
Oh, okay.
about how the court would prefer to proceed. Let's say that there was a case where to sustain felony charges, we need certain witnesses, but we can get to
Good morning.
I'm just trying to figure out if we may end up with one of these cases setting it onto a misdemeanor docket, and if we can't proceed with
With the felony.
with the felony. So
What's the hypothetical question?
I worked it out. I worked it out in my head.
Oh, okay, that
where-
works, because
I worked it out in my
I
head.
didn't think you had a question anymore there.
Yeah, I worked it out when I was formulating the question
Sounds
because I
good to
don't think.
me.
Morales' case.
I have looked at that one, yeah.
That's the RNO.
Yeah, he can plead to an RNO for. I guess he can plead to an attempt.
Let me see what he wants to do.
He can plead to an attempt.
I'll talk to him today. I'll be in tonight.
Yeah.
See you in the morning, guy.
Have a good one.
Yep.
Oh, okay, so on Anthony Jones.
Sure.
Mr. Bigelow, if you could me a favor, bring my iPad, just in my laptop bag.
Yes, sir. Did I sign the other?
No, he's,
Oh, okay.
Good, Nick.
yeah, thank you. I grabbed this file from
Haywood and
Jones.
Toby, can I talk to you about something like that? Yeah, give me one, let me just make a note here, so I don't forget. But I want to talk to you about.
Awesome.
Okay.
No, I'm. But you might want to ask her if you wanted this.
She's not muted.
We're not muted. I already signed it, Ollie. I don't have to put a note. Oh, you put the note, that's sufficient.
She's not muted. She's talking.
Ms. Deering, can you hear me?
Yes, I can.
Hi, I'm in the courtroom. Did you want to talk to me before we go on the record?
Not necessarily. I just wanted to do what we talked about yesterday.
Yeah, we can go over that. I'll get on the Zoom.
Okay.
I need to see her.
We're good.
Who's this here?
Harvey Evans, right?
On the record in the matter, the people of the state of Michigan versus Harvey Jesse Edwards, file number is 22-01440 FY, council parents.
Chris Martin for the people.
Toby White on behalf of Mr. Henry. He's with me here and we're on.
Mr. Edwards?
Yes. Henry.
Oh, okay, thank you. Today's the date that's set
Backwards
for,
now.
today's the date that's set for a preliminary examination. I think my last note was that we adjourned this because there was an effort to seek a global resolution and he had another pending matter. Was that matter addressed?
That's true, and I can elaborate a bit if the court would like. There is a charge that was issued and that it has been issued out of our office for an OWI involving a child. Mr. Edwards has not yet been arraigned on that matter, but I believe a summons has been issued. And I would ask that before Mr. Edwards leaves today, that he check in with the magistrate to see if that is pending here so that we can get that case moving. With respect to the,
Mr. Bigelow can see if it's pending now.
with
You see if
respect,
Mr. Edwards has another case pending.
with respect to the present case, there are a number of witnesses who have expressed that they're not going to appear on this case. However, we believe the case is sustainable as a misdemeanor. And with the witnesses that we have who are willing to appear. So we would ask that this case be set on the court's misdemeanor docket as an assault and battery. The people will provide a new complaint to the court. And the hope would be that by the time that's set for a misdemeanor, that the other case is moving on the same track and Mr. White and I can work out a global resolution again where we were last time.
Mr. White?
Thank you. That's a complete statement and we are in agreement with that plan of action.
Okay, so this will, your motion to amend it to an assault and battery will be granted. We will set this on a pretrial date and get you the date now.
They weren't.
Well, he's here now. Can you give me the file so I can arrange him? We will set it after I ring you another one so we can give you the same date. We're off the record. Just gonna go back to the file. Mr. Davis, are you present? Maurice Davis.
Your Honor.
Morning. Think we were treating today as a PCC?
Yes, that's correct. We were, Judge. I adjourned for discovery. I faxed my appearance over to the prosecutor. I haven't received the discovery as of yet. So I wanted to check on the status of my discovery request, and then, of course, I'm not ready to proceed with the exam. So I was going to ask to waive the 21-day rule so that I give them an opportunity to provide the discovery.
What, Mr. Davis, what email address did that come from? I'm not seeing it in my file.
I faxed it over to the prosecutor's office.
You faxed it?
Yes, I did.
What's a good email address for you? I can email you and copy our discovery unit. And typically the best way to get with them is to email the discovery unit your appearance, and then they'll get you everything you need. So if you don't mind, tell me your email address so I can do that right now.
You can use davislawmaurice@gmail.com.
Maurice at
Yes.
Gmail?
Yes.
All right, and I'm copying our discovery unit on that. So
Okay. Then I can reply with my appearance.
wonderful. Thanks so much.
Okay, I'm gonna have to go on the record to do their waiver. Mr. Wallace and Ms. Wallace, I see Ms. Wallace. Mr. Wallace, are you there?
Yes, ma'am.
Thank you. We're on the record in the matters of the people of the state of Michigan versus Trenton Wallace, file number is 22-02194. And then I have people of the state of Michigan versus Jada Wallace, file number is 22-02193. Mr. Davis, are you able to start your video? There you go.
Yes.
Okay. Okay. Can I have appearances for the record, please?
Chris Barton for the people.
Good morning, Your Honor. Maurice Davis, P76203, appearing with Trenton Wallace and Jada Wallace.
Okay, thank you. Mr. Wallace and Ms. Wallace, today is the date that was set for your preliminary examination. We were here last week for your PCC. You had recently retained Mr. Davis. He indicated at that time that he had not received discovery, and he's indicating today he still has not received the discovery. It looks like the prosecutor is going to try to make sure that communication is better streamlined so that discovery can be received and your attorney can review it and have appropriate time to formulate a defense for you. Because of that, the court's going to find good cause to go beyond the 21-day timeline. So you have the right to have your preliminary examination within 21 days of your arraignment, which is why it was set for today. But I'm going to find good cause to go beyond that timeline due to the discovery issue, okay?
Yes, ma'am.
Okay, do you have, either of you have any questions?
No, ma'am, not me.
Okay, let me get you, Mr. Davis, I'm gonna get you a new PCC and preliminary exam date.
Thank you.
September 8th.
Probable cause conference will be September 8th at 9:30.
Judge, would it be possible to go out to the 15th if you're doing it on Thursday? I have an arbitration on the 8th.
At 1:30.
At what time?
1:30.
September 15th at 1:30.
Okay.
September 23rd.
And the exam will be September 23rd at 9. Any
Those
additional
dates work
matters
for
for the
me.
record? I'm sorry?
Is it? Thank you, Judge. That works.
No problem. Any additional matters for the record today?
Only to say that I have emailed Mr. Davis and our discovery unit, instructing them to make sure that he has everything he needs to make his demands for discovery. File his appearance.
Thank you. Anything else for you, Mr. Davis?
No, I'm all set. Thank you.
Okay, you're all set, Mr. Wallace and Ms. Wallace. Thank you.
Thank you, Judge.
No problem. Okay, on the record in the matter of the people of the state of Michigan versus Harvey Jesse Lee Edwards. This is file number 22-02322 SD. Council appearance.
Chris Martin for the people.
Toby White. Sorry, Toby White. For the defense, and he is with us still.
Okay. So I could just authorize this yesterday. Okay. Well, this here, I have a misdemeanor complaint, Mr. Edwards. It alleges that on or about okay. It alleges that on or about May 7, 2022, in the area of 618 East Kalamazoo Street, City of Lansing, Ingham County, State of Michigan, you did allegedly commit the act in count 1 of operating while intoxicated with an occupant less than 16. It alleges that you did operate a vehicle upon an area designated for parking of vehicles, a parking lot at 618 East Kalamazoo Street, while under the influence of a controlled substance, while a Jaquan Edwards, a person less than 16 years of age, was occupying the vehicle. This is contrary to Michigan Compiled Law 257.6257AI. It says here, notice this offense resulted in damage to another individual's property or physical injury or death to another individual. That's a misdemeanor. Maximum penalty is a fine of $200 to $1,000 and not more than 1 year in jail or 30 to 90 days community service or both. Cost of prosecution rehabilitative programs may also be imposed, and you may also be imposed reimbursement for government emergency response and expenses for prosecuting defendant. You're also subject to vehicle forfeiture, and if not forfeited, vehicle immobilization. Do you understand the charge and the maximum penalty attached to that charge, sir? Okay, you have the right to be represented by counsel. You do have Mr. White representing you on another matter, and he's here today for the purposes of your arraignment. But you have the right to have an attorney represent you at each stage of the criminal prosecution. If you cannot afford to hire an attorney, but you economically qualify, you can request to have court-appointed counsel appointed to represent you at the expense of the public. Do you understand that? You have the right to proceed to a pretrial and to a trial on this matter. You have the right to have a jury trial. At the time of trial, you have the right to be presumed innocent until proven guilty. You have the right to have the prosecution prove each element of the charge being brought against you, and they have to prove each element beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used to prove or imply that you're guilty. You have the right to question any of the witnesses the prosecution intends to call. You have the right to call your own witnesses, and you have the right to present evidence that you believe will further a defense to the charge. Do you understand that? You also have the right to be considered to be released on bond pending your trial. Do you have any questions about your rights at this time? Lastly, you have the right to plead guilty, plead not guilty, or stand mute for the purposes of his arraignment. Does he want to plead not guilty?
Yes,
Is he going to be seeking to retain you, or does he want to do an intake for?
I believe he's seeking to retain.
Okay, so you're declining court-appointed counsel today, sir? Are you currently employed? Where are you employed? And that's in Lansing. Okay, and this address on Dibble, is that still your address? And I have a number here ending in 7653. That's still your phone? Okay. Okay, so we will set both of these matters for a trial on the same date.
September 13th, 9:30, if that works.
September 13th at 9:30 work for you, Mr. White?
Yes.
Oh. So both of these matters will be set for that time. We'll get you a notice to appear on both of those. Do you have any questions today, sir? Any additional matters for the record on either of these files?
Nothing from the people.
Nothing further.
Thank you. You're all set. You can have a seat. We'll get you a notice.
Thanks, sir.
Oh,
Yep.
sorry. Bond's gonna be set at 500 personal recognizance. Okay, let's see. Are we ready on Miss Deering?
I am, Your Honor.
On the record, excuse me, in the matter of the people of the state of Michigan versus Trina Deering. This is file number 22-01391 FY. Grab your appearances, counsel.
An Assistant Public Defender, Sarah Donnelly, on behalf of the defendant, Trina Deering, who is present and appearing separately by Zoom.
Thank you. How are you, Miss Deering?
You're muted, Ms.
muted.
Deering.
Okay, I can hear.
How are you today?
I'm good. How are you?
Well, thank you. Today's the date that was set for a preliminary examination. I do, however, have a plea sheet. Says that the people have offered for you to plead guilty to an added count of domestic violence aggravated under MCL 750.8A2. That's a misdemeanor. Maximum penalty is 1 year in jail and or $1,000 in fines. There's no objection to sentencing under 769.4A if otherwise eligible, and there's a Killebrew agreement of no upfront jail at the time of sentencing. Donnelly, that's accurate recitation of the plea offer.
Yes, Your Honor.
Okay, and you've discussed that with Ms. Deering today.
Yes, Your Honor.
Ms. Deering, do you want to accept this offer?
Yes.
Okay, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Thank you. You can put your hand down. Okay, Ms. Deering, you are represented by Ms. Donnelly from the Office of the Public Defender, and you have the right to be represented by counsel during the pendency of this matter. You have the right also to proceed to a trial. And you have the right to have a jury trial. At the time of trial, you have the right to be presumed innocent until proven guilty. You have the right to have the prosecution prove each element of the charge that's being brought against you. They have to prove each of the elements beyond a reasonable doubt. You have the right to question any of the witnesses that they call. You have the right to call your own witnesses or present any evidence you believe would further the defense to the charge. You have the right to remain silent at trial and not have silence be used to imply that you're guilty or to prove that you're guilty. You understand those rights?
Yes.
If you want to accept the offer, you would have to give up all of those rights today. Is that what you want to do?
Yes.
Okay, is anybody making any promises to you, not stated here on the record today, to get you to want to waive your rights and plead guilty?
No.
Has there been any threats made to you to get you to waive your rights and plead guilty?
No.
Are you pleading guilty to the charge because you believe you're guilty?
Yes.
Are you currently on probation or on parole?
No.
You understand that a guilty plea to the added count of domestic violence aggravated could result in a conviction that you may need to report to your current employer?
No.
Okay, so you probably want to discuss that with your attorney because you're likely gonna have to report a conviction to your current employer and you will likely have to report that to a future employer. And you can discuss how that might impact your employment. I don't know what kind of employment you have, but if you were in a place where you maybe worked with children, that could have a devastating impact on your employment, this plea, okay?
Okay.
Do you want me to
My
put you back in?
was that it wouldn't, like the employer wouldn't see this.
Well, there's a request for sentencing number under 769.4A, but you've not been granted that yet. So that's why I'm saying there's a potential that could take place. You have to be screened to see if you're eligible for 769.4A.
Okay.
Okay, so you understand that this guilty plea could have an effect on your, or you may have to report this to your employer or put it on a future job application. You understand that?
Yes.
And that's only if you're not granted 769.48, or if you're granted it and then you somehow lose that status by violating your probation and losing the special status. You understand that?
Okay. Yes.
Okay. And then you're not on probation or parole at this time, correct?
No.
Okay. Also, there's a Killebrew agreement. That's an agreement about how you're going to be sentenced, and that's an agreement between you and the prosecutor's office. The court is not a party to that agreement. So that means that at the time of sentencing, if I decide that I'm not going to follow that agreement, I'm going to sentence you to jail, I will then give you an opportunity to withdraw your plea, okay?
Yes.
As to the added count 2 of aggravated domestic violence, how do you plead?
Guilty.
Can I have a factual basis, please?
All right, thank you, Your Honor. Ms. Deering, on or about February 14th of 2022, were you at your residence on 3312 North Waverly Road in the city of Lansing, Ingham County, state of Michigan?
Correct.
All right, and on that date and time, did you physically discipline your son Elijah with on his arm with your hand, and did it leave a bruise?
Yes.
Okay. Your Honor, I have no further questions.
Any questions from you, Mr. Ryan?
Did Elijah seek medical treatment at his school from the school nurse?
I wasn't notified about that.
You became aware later that Elijah sought medical treatment at his school from the school nurse. Is that safe to say?
On my paperwork, yeah. When I seen that you guys had a witness, yeah. But I was not told that he seen a nurse at the school of the day.
I think one of the elements for an AGV is that it has been an injury that requires medical treatment.
Oh, I was doing for the child abuse.
Oh, so you.
So factual basis for the child abuse for, that's fine.
Okay. Thank you. The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing, and I'm going to refer you to probation so that they can prepare a pre-sentence report and provide a recommendation. So you need to report to the probation department, which is on the 5th floor of this building, within 48 hours in person, okay?
Okay,
And that's 48 business hours, just so we're clear. And we're closed on Monday for the holiday, okay?
okay,
Tuesday morning.
Okay, and so they'll get you set up for your pre-sentence interview. And they will also advise the court if you are eligible for 769.4A, okay?
yes,
Your sentencing date's gonna be Friday, October 21st at 8:30 in the morning. Have any questions today?
no,
Any additional matters for the record today, council?
None from the people, thank you.
None for defense. Thank you, Your Honor.
Okay, you're all set, ma'am. Thank you.
When I used to practice in Virginia, to do a guilty plea, the prosecutor reads a summary of, their theory basically. And the judge just asks the defendant, do you agree with that? And that's the factual
Oh,
basis.
Virginia.
Yeah, you know.
Yeah.
You're on a couple more cases. I'm gonna go see if my witnesses are
Yeah,
here.
she treated Blackman. She's out there. What about Tuttle? Someone's asking about him on the Zoom.
Is he here?
Yeah, he said.
Mr.
Do we have our
Tuttle.
officers here?
You
Let's
do
get
that
one
one
over.
You do that one? Yeah. Absolutely, show. Awesome.
Let's get it over.
Okay, to the person asking about Caleb Tuttle, the parties are making sure they have witnesses, so that should move forward shortly. On the record in the matter of the people of the state of Michigan versus Caleb Tuttle, file number 22-02195, FY appearances for the record.
Chris Martin for the people.
Thank you, Your Honor. Robert Palmer, the Total Defender's Office, on behalf of Mr. Tuttle, the gentleman who's standing to my right.
Thank you. Today's the date that was set for preliminary examination. I think I asked you in the hallway, but how are you, Mr. Tuttle?
Good.
Okay. Okay. And so my understanding that there's going to be an unconditional waiver of the exam to the circuit court, correct?
That's the correct statement.
Was there an offer on this?
Yes, Your Honor. The offer is that Mr. Tuttle will plead guilty as charged with the circuit court. People affirmatively agreed not to increase the charge to an RNO causing injury. And we expect that there will be negotiations on sentencing. at the circuit court.
Mr. Palmer.
That is correct, that statement, Your Honor, and we also anticipate potential HIDA.
Correct.
That would be a continuation of the negotiations.
Okay. Okay, Mr. Tuttle, you understand that you have the right to have a preliminary examination here in the district court. You understand at the time of your examination, you have the right to have the prosecution meet their burden of probable cause. And they have to establish that there's sufficient probable cause that a crime was committed, and sufficient probable cause to charge you with the crime. Do you understand that?
Yes.
You wish to unconditionally waive your exam today?
Yes, ma'am.
So that means you can't come back later and decide that you want to have your exam or that you misunderstood. Once you waive your exam, it's gone. You understand that?
Yes.
Has anybody promised you anything to get you to want to waive your exam?
No.
Is anybody threatening you to get you to waive your exam?
No.
Are you waiving it freely and voluntarily?
Yes.
Is this your signature here, sir?
Yes, it is.
Okay. I find you waived it made freely and voluntarily. I'll bind the matter over to the circuit court. Your bind over date is going to be September 14th, 2022. That is not a date that you will need to appear in court though, okay? That's the date that the circuit court will receive the file from this court. Your next court date will be a pretrial in circuit court. Mr. Palmer will be made aware of that date. You will not need to be arraigned again in circuit court unless Mr. Palmer files a motion indicating why you need a new arraignment, okay? Do you have any questions today? Was set at $4,000 personal recognizance with GPS. Tyler, are we addressing bond today?
No, Your Honor, there was an issue. He did not get out of jail until yesterday because of the power outages at the jail and JSG's inability to get in there. My office tried to get this going expedited, but it sounds like everything's cleared now, so he should be good. The only other issue, Your Honor, I wanted to bring to the court's attention is that my client has a different phone number now, so I want to make sure that that's part of the record.
Okay, what is the number?
The number is 517-894-7140. That number actually belongs to his sister, Destiny Brown. That is necessary. That's the necessary contact because it's my understanding the plain witness in the count still has all of Mr. Tuttle's property and refuses to return it. So that would include his cell phone. So his cell phone is no longer accessible to him, obviously, because of no contact order.
Okay, give me the last four digits again.
7140.
Okay, very good. All right, our file will be updated with that information. Any additional matters?
Nothing. Thank you.
You're all set, Mr. Tuttle.
Thank you. Have a good day.
Same to you. Mr. Carter, did you need something else from me?
No,
I'm gonna bank warner. Yep,
Thank you.
no problem.
You know, there's one matter left on the morning docket. It's the matter of Kent Hamilton done. I need to check and see who's all here for that. That potentially will be an exam.
Sounds good. For the record in the matter, the people of the state of Michigan versus Kent Hamilton Dunn, file number 22-02221, FY council appearance.
Chris Martin for the people.
Thank you, and good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Kent Dunn, who's
Thank you. How are you, Mr. Dunn? How are you? I'm well, thank you. Today was a date that was set for preliminary examination. Are we ready to proceed on this?
Are you, there are a couple of preliminary matters I'd like to address in the court.
Proceed.
We are prepared to begin our exam with the testimony of Officer Jacob Ellis today. He's present in the courtroom. There's another officer involved who we will need to complete the exam. He's not available today. It's my understanding that he is out of town. His name is Officer Doug Hall. But we will be beginning the exam today. The other piece I'd like to inform the court of is that the people intend to add a third count of felon in possession of a firearm. And we would ask the court to take judicial notice of Mr. Dunn's CCH pursuant to MCL 766.11B. That Mr. Dunn was convicted of multiple felonies, but most recently of possession of methamphetamine, a 10-year felony on September 10, 2021. I'm showing a copy of the CCH record. Right now. If I may approach, Your Honor.
You may. Mr. Palmer? Did you want to respond?
Your Honor, I would simply say this. I certainly have seen the document from Mr. Martin. I think, Judge, my client has instructed me not to stipulate in this matter. I think that technically that is supposed to be a certified count. 766.
It is supposed to be a certified copy. We're not able to get a certified copy.
Well, this is I believe that 76611B allows for purposes of preliminary examination for a state record kept in the ordinary course of business to be admitted for purposes of a preliminary examination. This is how we get lab reports in from the Michigan State Police that are not certified records. However, we are not going to be able to complete the exam today, so we can return with the certified record. But I believe that the statute is designed to prevent a situation where the only holdup is waiting on a certified record.
Well, I was going to suggest the same thing. We're obviously not going to continue today, so we'll just bring the certified record, and that will satisfy any objection. But
I would agree with that, Judge. Obviously, if we have to come back, it's certainly thing. And Mr. Martin, if Mr. Martin could show me that certified copy, I think I'd have to stipulate to it at that point. I'd have no basis to block it.
okay, sounds good. And so, were there any other preliminary matters for you today, Mr. Martin?
Nothing further from us.
Okay, so anything from
Your Honor,
Mr. Palmer?
the only thing I would suggest is that particularly if we're going to be coming back another day, I would ask for sequestration of witnesses, and I would ask that any officer's testimony taken today not be posted on YouTube so that it remains sequestered for testimony on further dates or on additional dates.
Sounds good. I'm assuming there's no objection to that.
I have no objection.
Okay.